Hi, it's Mike Del Signore, Massachusetts criminal defense lawyer. In today's video, I want to talk about what happens if you're charged with open and gross lewdness in Massachusetts. If you're charged with an open and gross offense, keep in mind it's not a sex offense unless you have a prior conviction. So what I generally try to do to start, let's assume you're charged, you're arrested, and you have court on Monday or the next day. We'll enter a not guilty plea at the arraignment, and then what we'll try to do is we'll try to fight the case on two fronts. One, we'll see if we can work out a resolution that you can live with, because a resolution is something sure, whereas a trial can be an uncertain outcome. So generally, to give yourself the highest number of options, I'll suggest doing some kind of treatment that addresses the allegations in the complaint. Now, this doesn't mean you're admitting the allegations are true. It just gives me more to discuss with the DA. It gives them greater ability to reduce the charge or give you some kind of pretrial probation or some kind of resolution that you can live with. Let me discuss some of the types of ways these cases can be resolved. Best way for it to be resolved would be what they call pretrial probation. That would mean the case would get continued for a period of time if you stayed out of trouble and complied with some conditions, which there probably would be conditions such as treatment, counseling, alcohol treatment, then the case would get dismissed. So that's not an admission of any kind of wrongdoing. It's just an agreement with you and the DA that if you do these 2 or 3 things, don't pick up any further charges, the case will be dismissed. Sometimes DAs won't agree to that. The next best resolution is to take the open and gross charge and to have it reduced to a misdemeanor, which would be indecent exposure, and have you accept a continuance without a finding. Continuance without a finding is an admission to some wrongdoing, but on that charge, it's a misdemeanor offense. You'd be admitting that you exposed yourself, but the misdemeanor element. So an open and gross has the additional element of there was an intent to cause alarm or shock, and that transfers it into a felony offense. So that would be plan B. If they don't accept that, then they might be looking for an admission on the open and gross charge. A continuance without a finding would not be a conviction. Maybe they'd be satisfied with probation. But at that point, we'd have to decide, do we want to admit to the charge, or do we want to try to take it to trial, see if you can be found not guilty of the charge. So in a case like this, it starts with doing treatment, counseling to give yourself the most options, discussing the case with the DA, and then finally taking the case to trial. Some of these cases, there's identification issues. Sometimes the witnesses don't want to appear. So these are winnable cases at trial. Just the thing is, once we get to trial, if you're found guilty or you lose, then everything is up to the judge. So many of my clients, I've represented a lot of people in this situation. Most of them have found the counseling fine. Even if we don't need it, it's usually helpful for people to get see counselors, talk to these people. They're trained professionals. They can provide you a lot of advice and insight. So there's no downside of doing that. And then what I would do is I'd send a letter, they call it a mitigation letter, to the DA, see if they'll go along with it. These cases, generally it takes a few pre-trials. Sometimes they have to reach out to the alleged victim in the case. They want to sort of the DA represents the victim. They want to make sure the victim's okay with the resolution, is on board with everything. So we want to present what happened in the full picture and try to mitigate what they're alleging happened in order to get some kind of agreed resolution to the case. And that's a common strategy. So in a criminal case, you're initially charged, you're presumed innocent. Enter a not guilty finding. Government's got to prove this charge beyond a reasonable doubt. They got to prove the 3 elements of the offense. Sometimes there's motions to dismiss or legal issues where even if the allegations are true, it doesn't quite meet the elements of the offense. So if you need help with a case like this, you want advice, you need me to represent you in court, I appear in courts throughout Massachusetts. I'll be glad to help you. My name is Mike Del Signore. Call, text anytime. My passion is helping people make the best decisions for themselves in a criminal charge. Get a second chance, get your life back together, and get these criminal charges that are probably taken away from your family, maybe impacting your work, remove them from your day-to-day life and your thought process. I know how a criminal charge can consume people once they're charged, and I want to help you understand the process so we can move through it as quickly as possible with the best outcome obtainable.